Good afternoon, sir. Can you see and hear me?
I can indeed, thank you.
Thank you, sir. This afternoon we're going to hear from Mr. Clark.
Of course.
I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
the evidence I shall give
shall be the truth,
should be the truth,
the whole truth,
and nothing but the truth. Thank you.
Thanks.
Thank you.
Thank you very much. Can you give your full name, please?
My name is Gregory David Clark.
Thank you. You should have in front of you a witness statement.
Indeed.
Is that dated the 28th of June of this year?
It is.
Could I ask you to turn to the final substantive page? That's page 47.
Yep.
Can you confirm that that is your signature?
It is.
And is that statement true to the best of your knowledge and belief?
It is.
Thank you very much. That has a unique reference number of WITN 109000100, and that will be uploaded onto the inquiry's website. Mr. Clark, you were a Member of Parliament between 2005 and this year, is that correct?
That's correct.
You've held a number of different ministerial posts. You were served as Minister of State in the Department of Communities and Local Government, is
That's
that
right.
right? You were Financial Secretary to the Treasury.
I was.
Minister in the Cabinet Office.
Yes.
Minister for Universities and Science.
Correct.
Secretary of State for Communities and Local Government.
That's right.
And relevant to today, you were Secretary of State for Business, Energy and Industrial Strategy. And that was between the 14th of July 2016 and the 24th of July 2019.
That's correct.
Thank you. That was during the premiership of Theresa May.
That's right.
Thank you. I'm going to begin just with a little bit of background before your time as Secretary
Sure.
of State. And if I could ask to be brought up on screen, poll 000097393, please. I'm going to take you to some correspondence relating to a constituent of yours.
Yep.
And this is a letter from yourself to the Right Honourable James Arbuthnot, and you are in contact with him regarding your constituent, Mrs. Pauline Thompson, who the inquiry has heard from in an earlier phase, who wished you to refer her case against the Post Office on to Second Sight. Mrs. Thompson has now stated that she's happy for Second Sight to proceed with an investigation of her case, and she has confirmed that she understands her details will be seen by the Post Office. Did you have a number of different cases around this period from sub-postmasters as a constituency MP?
This was the only one in my constituency that I was aware of at the time.
Thank you very much. And you were corresponding with Lord Arbuthnot in relation to
Correct.
Second Sight investigation into her case.
That's right.
And could we please turn to poll 002328847? We're now moving on from January 2013 to March 2015, so quite a considerable time has elapsed. And it relates again to the same constituent, Mrs. Thompson. And in this letter, you're corresponding with Paula Venables about a letter that Mrs. Thompson received only a couple of days after being told that her case would proceed to mediation.
Correct.
And if we turn over the page, we can see the letter that you have enclosed. The letter is marked as confidential, not to be disclosed outside of the scheme of mediation. It's dated the 5th of February of 2015. So it's during a period where we know that the working group is being shut down.
Yes.
And I'll just read to you a couple of passages from the letter that was sent to Mrs. Thompson. It says, "You will be aware that your case has been looked at afresh and thoroughly reinvestigated by Post Office. Your case has also been considered by the scheme's independent forensic accountants, Second Sight Support Services Limited. The reports of both of these investigations have been shared with you. As you will know, Second Sight recommended that the question of responsibility for losses incurred in your branch should be mediated. In the event, the scheme's working group considered that the issue was suitable for mediation on a deferred basis." So it seems as though Second Sight and the working group both considered that Mrs. Thompson's case was suitable for mediation.
Indeed.
And then the letter continues, I regret to inform you that after careful consideration, Post Office takes a different view and has decided against proceeding to mediation in your particular case for the reasons I set out below. Responsibility for losses. Post Office considers that the question of responsibility for the losses suffered in your branch was appropriately addressed at the time of the suspension of your contract with Post Office on the 12th of September 2008 and your subsequent prosecution and conviction. It remains Post Office's view that the conclusions drawn at the time were correct and nothing in our own reinvestigation nor in the review of your case by Second Sight represents a challenge to that position. So a refusal to mediate the case on behalf of the Post Office. Did you meet with this particular constituent at the time?
I can't remember. I certainly met with her on several occasions during the long period in which I've been trying to help her resolve the case.
And we'll come on to talk about the particular case in a moment, but before I do, I will just take you to a response that was received to your correspondence. That can be found at poll 001173339. Thank you very much. So this is a response from Miss Angela Vanderbogerd to yourself. And if we scroll down, she says there is in fact no inconsistency in the two communications she received. The first communication she received enclosed Second Sight's final independent review of her case, including Post Office's investigation into the matters it raised. In these reviews, Second Sight offer their view as to whether a case might be suitable for mediation. However, while this is their view, all mediations are entirely voluntary. The final decision on whether or not to mediate a case ultimately rests with the parties involved. It follows that either party can decline to take part. Mrs. Thompson's case has been thoroughly reinvestigated through the scheme, and after careful consideration of all relevant facts, including Second Sight's final report, the Post Office has concluded that mediation does not offer any realistic prospect of resolving your constituent's complaint for the reasons set out in the letter to her. Prior to becoming Secretary of State, so in this period, what was your understanding of the issues relating to Horizon and Second Sight?
My principal understanding, I think, in fact, all of my understanding, came from dealing with Mrs. Thompson. And it conditioned my view of certainly the management of Post Office Limited. I mean, on the documents that you've just put up, I don't know whether we can have that second one again. That reply from Angela Vandenbogard, I think she was called, I thought was an impudent reply. She didn't answer the question as to why Mrs. Thompson was being refused the ability to arbitrate. Indeed, if we look at it, I think they even get her name wrong. Just noticed
That's going to be brought up onto screen
now.
Thank you.
Mrs. Paula Thompson, she's called Pauline Thompson. It doesn't say why. It merely asserts that despite the fact that Second Sight and this panel had recommended it, they say that, well, we simply decided that we don't want to. Either party can decline to take part, and so they've done so. I thought it was an impudent letter to receive in reply to mine to the Chief Executive, and it conditioned, as I say, my view of the management of Post Office Limited.
Thank you very much. That can come down now. You took office in July 2016, and I'd like to take you to the introductory brief that was provided to you. That can be found at WITN 109-00103. At paragraph 33 of your witness statement, you've said that you received introductory briefs from each of the 40 or so directorates in your department.
Correct.
Is that right?
As is standard.
So is this kind of a brief that we're going to see, is this typical of the kinds of briefs that you would receive in relation to the areas for which you had responsibility?
Fairly typical. I mean, some were more substantial than others. For example, at the time that I took office, one of the first decisions I had to make was whether to approve the Hinkley Point C nuclear power station, which was and is the biggest construction project in Europe, I think, at the time. So obviously the briefing for that was necessarily more substantial, but this was not untypical of many briefs that I received.
Are you able to assist us with who might have been responsible for drafting this?
I infer from knowing, I think with the benefit of hindsight, the structure of things now, that this would have been from UKGI, someone in UKGI, perhaps Mark Russell, who was the CEO, who we may come on to discuss, regularly briefed me, because I think I'm right in saying that there was not a post office team within the department at that point, and so I assume that came from them.
Thank you. If we scroll down, we can see it begins by outlining some key facts about the post office. It then addresses the department's role, and I'd just like to read to you the first paragraph from the next page. It says, the BEIS Secretary of State is the sole shareholder of the post office, and UKGI manage that shareholding for BEIS, representing government as the post office's shareholder and with a position on the board. UKGI also acts as a voice/guide for the post office within government, and it maintains relationships with key departments such as HMT, Cabinet Office, and DWP. So it seems as though they represent, UKGI represent government as Pol's shareholder, but at the same time act as a voice/guide for the post office within government. How does that work?
Well, how it worked then, before there was a team in BEIS, was that regular meetings and briefings and communications to do with the post office would come from UKGI, principally actually to the post office minister at the time, rather than me directly as Secretary of State. But as I say in my witness statement, one of the things that I instituted right at the beginning of my tenure was to require each of the Directors General, which is to say the layer below the Permanent Secretary, to give me a weekly report, just to me, of anything on their mind. And one of them came from Mark Russell, who was the Chief Executive and therefore the equivalent of the DG of UKGI. And so each week I would get what was on his mind through that directly, but most of the detailed submissions and contact would have been with the Post Office Minister.
And irrespective of individual personalities, is there a tension between representing government at the post office and also acting as a voice/guide for the post office within government?
I think there is a tension in many respects, and we may come on to talk about that in more detail. I actually think there is a structural tension, and arguably, at least in the view of the department, something of a legal tension, in that in a fiduciary board, the responsibility of a director, and the UKGI director was as it were, a fully fledged director of the organisation, there is a kind of unitary responsibility to the company. And in particular, my understanding, and certainly it's consistent with advice during this period, was that in terms of the department, and indeed the government, directing or influencing the board through that director, that was a perilous thing to do, that there was something known as the shadow director risk, in which if from the outside, whether collectively or through an individual, you directed the board's decision, then you could be counted as a director yourself. In my view, I'm sure we'll come on to talk about this, rather than seek to sort of dance around that, I think it would have been better for it to be perfectly legitimate for ministers and officials in the department to input directly without any of this kind of tiptoeing around to the decision making of the board. But it was constituted that way, and that's how it was at the time.
Moving down to policy areas, it says government's policy on the post office is to set the parameters within which we expect it to operate, reach of network, types of services it should seek to offer, and then allow the business to operate commercially at arm's length from government. A post office is a corporation with a fiduciary board. Operational decisions are made by the CEO, Paula Venables, and her team, supported by the board. CFO Al Cameron, who you're meeting, is the other executive on the board. That's another thing that we've heard quite a bit about, operational decisions.
Yes.
Was that something that could be easily separated out when it came to, for example, matters relating to sub-postmasters?
Well, I think, as other witnesses have said, I think there is no bright line. Certainly there's no definition that sets this out. The view of the department, the inherited view across different administrations of different parties, was that certainly what counted as operational included matters like IT systems and the relationship with the sub-postmasters, and therefore that was definitely in that category. Things that were strategic, obviously, was government requirements on how many post officers were to be there. But clearly, and no doubt we'll come on to talk about this, within the middle, there are questions as to when operational matters become strategic, or certainly kind of proper for ministers. And my view, as set out in my witness statement, is that I think in certain government-owned organisations, of which Post Office Limited is one, I think there is a greater likelihood of that to happen than in some others. For example, Lloyds Bank, when it was owned by, at least in part, by the taxpayer.
Thank you. It seems there that you were going to be meeting with the CFO, Al Cameron. Do you recall a meeting with Mr. Cameron?
I do recall meeting with Mr. Cameron and indeed other executives throughout my period in office. What has been a bit frustrating, and I think other witnesses, including Sir Vince this morning, have said, is that for reasons I don't understand, the department don't have access to, whether they don't have at all, ministerial diaries and minutes of meetings. That surprises me and disappoints me. So in a 3-year, 10-year meeting, literally thousands of people a year, I'm unable to say how often and when, but certainly I met Mr. Cameron, and probably from this I met him shortly after this note was sent.
Thank you. If we scroll down, we can see various headings. We have ownership, services and long-term strategy, network. If we keep on scrolling, at the bottom of the next page, pensions, cash supply chain, industrial relations. And then we come to other issues. Yep. And under other issues, it says as follows. It says, following complaints from a small number of sub-postmasters regarding the Post Office's Horizon IT point-of-sale system, an investigation was undertaken by an independent firm, Second Sight, over 2 years. Whilst this received relatively high-profile press attention, no systemic issue with Horizon has been found. However, affected sub-postmasters continue to put pressure on the Post Office. The Criminal Cases Review Commission are considering some cases where individuals have received criminal convictions, and group civil litigation is being launched against the Post Office in the High Court. It seems as though that is the only mention of Horizon-related issues within this brief. Is that right?
It is, yes.
And do you consider that brief to be sufficient?
Well, it contains, in my view, the crucial information, which is in that last sentence, I think it is, that the Criminal Cases Review Commission are considering some cases by implication, of the safety of the convictions, and that litigation is about to begin in the High Court. That communicated what I thought was the essential information on that.
Did it give you, for example, an idea of the scale of the group litigation?
No, it didn't, clearly.
And it begins by saying that there were complaints from a small number of sub-postmasters regarding Horizon IT system. Do you, now looking at it, do you consider this summary to be an accurate and fair summary?
Well, certainly it wasn't a small number. I think, if I were to be fair to the authors, I think the number of sub-postmasters that were part of the group civil litigation increased. I think it started off not small, but smaller than it ended up, and that grew over time. But in some ways, the number was not the most important point. It is a important point, certainly, but I didn't think it was the most important point, because the most important point is that people are talking about criminal convictions that are in front of the CCRC. Now, my view is, and bearing in mind that I was working with a constituent who was absolutely sort of an example of this, if she'd be the only one, that would be enough.
It refers there to Second Sight investigation, and no systemic issue with Horizon has been found. Were you aware, for example, that Second Sight had produced a report which identified 2 bugs that they went into detail and a further bug?
I wasn't aware of that.
Were you aware at this stage of any concerns about an expert witness who had appeared in a criminal case or criminal cases?
I certainly was not.
You, in your witness statement, it's paragraph 36, you say that you've reread all 150 or so weekly updates that were provided to you while you were Secretary of State, and there's minimal reference in there to issues relating to Horizon.
Referring to the litigation, to Horizon, yes, and it was through the lens of the litigation, essentially. It was an update on that.
We'll come to examples and to detail,
yes.
But do you think that you were sufficiently briefed in relation to matters relating to Horizon?
Well, were it not for the fact that these cases were before the courts, what I say in my witness statement is that the view of the department, and you may ask me about, as it were, my own view of this, the view of the department was that these matters were essentially sub judice and were, perhaps not technically so, but they were being tested in 2 judicial forums, if I can put it that way. One with the Criminal Cases Review Commission and the other in the High Court. And therefore, the determination, the discovery of the truth about this was taking place through that process. So in that sense, I think it was proper that the court was sitting in some cases daily to examine that. And so the updates when it came to Horizon were on the progress of the litigation. So
the courts had charge of the matter.
Yes.
You were being updated
and
about
the CCRC.
And you were being updated about their progress.
Yes.
But looking at this, this one paragraph plus the weekly briefings that you've looked at, do you think that that was sufficient in relation to the overall picture of problems with the Horizon system?
Well, I describe in my witness statement as this period being a period, I think as I described it, between 2 times. And what I mean by that is that up until, I think, 2015, prosecutions were being made of sub-postmasters. They had come to an end. The legal processes had commenced. Both the CCRC, I think, had commenced the year before, and the group litigation had started, I think I was appointed in July in the April. But they neither clearly had been resolved. So this was a kind of time of limbo in some sense between the end of the Post Office taking forward prosecutions, but before the opinion of the courts, High Court and the Court of Appeal, had been issued. So the role of the government, I would say, in resolving those problems was, and certainly sort of mounting prosecutions, was not the same as it was before or after.
Could we please turn to poll 0011715, please? On becoming Secretary of State, you received a letter from Paula Venables. That's the 25th of July 2016. If we scroll down, she congratulates you on your appointment. If we scroll down, we can see the significant strides in modernising the network that she refers to. And if we go over the page, please. It says, we're therefore developing a new strategy to 2020-2021 designed to strengthen our market position, improve our digital capabilities, and radically reduce our operating costs. While this will require investment to execute, it provides an historic opportunity to complete the commercial turnaround of the Post Office and put the network on a self-sustaining footing. Do you recall receiving this letter?
I don't recall it, but I'm sure I did.
There's no mention in this letter of Horizon issues.
Indeed.
Do you recall in your early time as Secretary of State or even thereafter discussing Horizon issues with Paula Venables?
I don't have any recollection of that.
And how about Al Cameron, who you have met perhaps more regularly?
I can't remember that, but again, I would say that the litigation and the Court of Appeal, the CCRC, were the most important parts of that. And as I say, the view was that these were effectively being determined in court rather than between ministers and the Post Office at that stage.
And you say the view, that was of those who advised you. Was that your view as well?
Well, so going back to your first questions to me, Mr. Blake, I had an insight into this through one particular constituent. And it led me, I think, that correspondence, and there's others that we might have looked at, that I didn't trust the management of the Post Office, to be frank. I mean, take that unilateral refusal to Mrs. Thompson to have her case arbitrated, despite the fact that the panel or whatever it was had recommended it. That led me to suspect that the current management of the Post Office were not to be trusted to resolve some of these questions. So the view of the department, as I say, the inherited view that Horizon, IT systems, contracts with sub-postmasters, etc., were kind of operational, and therefore litigation around it was for the Post Office itself. My view was to welcome the fact that the court was going to look at this, the High Court in particular. I thought the authority of a High Court judge and the requirements of disclosure and all the rest of things was a better way of resolving this than, as it were, a process that involved the Post Office, any kind of arbitration with the management of the Post Office.
So pausing there at, say, 2016,
Yes.
who, if anybody, did you think should have been providing you with more information about the Horizon system? Or is it your evidence that, in fact, you are satisfied with the level of information you were being given at that time?
I would say that what I was relieved that the High Court and the CCRC were, with the powers available to them, going to determine the truth about what went on there. I had no evidence to think that or to know that the Post Office were behaving improperly, but certainly the experience of a constituent who I should say was a well-respected person in the community, was a person of sort of blameless character, had been treated in this way, not just charged and convicted, but subsequently been treated in this peremptory way by the Post Office. There are other letters about demanding repayment of funds even after she was sentenced. I was very keen that the courts would determine the truth here rather than relying on the Post Office.
Moving on in time now to 2018, could we please turn to UKGI 407712? There seems to have been a letter to you from Ms. Eleanor Shake in respect of a sub-postmaster. This is a response from your Minister, Margot James. This particular version is unsigned. We have two different versions, one from Margot James, and we also have a later one from UKGI as well. I don't think we can say whether this particular one was sent or wasn't sent. I think the assumption is that this did go. And she writes as follows. You've been written to in relation to the suspension of Farncombe Village sub-postmaster following a post office audit in 2017. She sets out there the government recognising the importance the post office plays. And then there's a paragraph. It says, I should explain that the government sets the parameters in which the post office operates, including its geographic reach and the key services it offers, and then allows the post office to operate as an independent commercial organisation within those parameters. As such, we do not play a direct role in the day-to-day responsibilities of the company, and this will include matters concerning the investigation and suspension of sub-postmasters. Just pausing there, is there a difficulty with this clear distinction when it comes to, for example, prosecutions of sub-postmasters? Do you consider prosecutions of sub-postmasters to be purely operational matters, or might there be more to it?
Well, first of all, I didn't know that the Post Office itself prosecuted at that stage sub-postmasters. In the case of my constituent, I'd known that the police arrested her, and so I kind of inferred from that that it was a normal process, so I was not aware of that.
Thank you. Irrespective of what happened in that particular case, as a principle, do you see the prosecution of sub-postmasters to be a purely operational matter for the Post Office, or are they something else?
Well, I think it depends. Every organisation will, from time to time, have instances in which they have to take disciplinary action against either an employee or, in this case, someone that it has a contractual relationship with, whether that's a retail group, whether it's a corporation. So, leaving aside whether they should have the power to prosecute themselves, the fact of people being prosecuted, I don't think is necessarily a strategic thing. What clearly does make it strategic is whether those prosecutions were mounted in a way that was, I'm afraid, corrupt. And we now know, from what has been disclosed, that the Post Office was in receipt of information that at least one of its witnesses during those trials was unreliable, and certainly I'm not sure of the timing, whether people, once they knew it, were continuing to be prosecuted despite the knowledge of that. But certainly the case that people that had been prosecuted had to live their lives as convicted people because of it. Now that not only raises it to the level of strategic, it raises it to the level of being totally unconscionable. So from the spectrum of one or two people in a large organisation being prosecuted for misdemeanours from time to time, to what seems to be the case that at least in some parts of the management of the post office, people were prosecuted, in some cases jailed, in some cases people lost their lives on the basis of information that we now know and was known to them to be wrong, is of a whole different order.
If we look at the final paragraph there, it says, the Post Office have also assured me that they are confident that the Horizon system is robust and reliable. It is used by over 11,600 branches for numerous services every day and has been for a number of years. It is right that the Post Office should investigate these sorts of instances thoroughly, given it is charged with overseeing substantial amounts of public and third-party funds. Were you aware of these kinds of stock lines being sent out to people who wrote to either yourself or to your ministers?
I can't remember, but it wouldn't surprise me. They were, as you say, the standard lines that had, I think, prevailed for many years under different administrations. If I saw this, I would have regarded it as, in effect, a holding line. It says the Post Office have also assured me, it comes from Margaret James, but it says the Post Office have assured me. I wanted to see the Post Office's assurances tested rigorously in court, and that's what was going on during this time.
And could we turn, please, to UKGI 407733? This is another response to Mr. Sheikh, this time February 2018. It says, thank you for your email of 13th of January 2018 to Greg Clark MP about Farncombe Post Office. And then if we scroll down, very similar terms towards the bottom.
Yeah.
Again, same number referred to there. It's used over 11,600 branches, etc. And this one is sent by Stephen Clark of UKGI. Was he somebody that you worked with?
I can't remember. I mostly dealt with Mark Russell, who was the head of the organisation, but he may well have been in meetings accompanying Mr. Russell.
I want to turn now to the common issues judgment.
Can I just make a comment on,
Absolutely.
On that, since you've got it up? I think looking back, does it say what date the letter?
If we scroll up, 13th of January was the letter to you.
In 2018, beginning of 2018, I think if I to look back, I think what it would have been better to have said was what I've just said to you, that actually these matters are being tested by the High Court and will be determined shortly.
Thank you. And that can come down. I'm going to move to the common issues judgment. The judgment itself was the 15th of March 2019.
Yeah.
It seems, certainly from the paperwork that we have, that Horizon didn't really feature very much in your briefings between 2016 and March 2019. Is that a fair summary?
Well, only to the extent that it was before the High Court. It was obviously until the judgment was issued. That was where, as it were, the action was, and there were updates on that. The Post Office minister at the time, I think, got a regular update. I mean, I say in my witness statement that there was some reluctance even to give those factual updates of what was going on. But that's not to say that I didn't regard that court process, as I hope is evident, as being very important, and the prospective judgment as being important, because before we get to that judgment, you'll see from my witness statement that I took steps to, as it were, to prepare for the receipt of that judgment, even to the point of asking whether the government, the business department, could have early sight of that judgment. I was advised that this was not possible because we weren't a party to the litigation. I asked the permanent secretary to, outside the UKGI process, to advise me and the then Post Office Minister in anticipation of the judgment as to what his assessment of how we should handle it was. So this, throughout it, I'd regarded this court process as being extremely important, and therefore the judgment, I had no idea what it was going to say, but I was looking forward to it, shall we say.
Can we turn to the advice in relation to the draft judgment? That can be found at UKGI 409076. And it's a ministerial submission to you of the 1st of March 2019. And we see there you are noted there to note.
Yes.
Do you know who drafted this? There are a number of names there.
I assume from sort of deciphering the norms on these things that Tom Aldred, who was marked as the lead official, I assume that he would have drafted it, but that it would have been approved by Mark Russell. In fact, I required that Directors General approve statements like this.
Thank you. And it's headed Judgment in Post Office Common Issues Trial. And it says a judgment in the Common Issues Trial will be sent to the parties next week. And if we scroll down, there's some advice. It says on paragraph 5, you have asked for advice on whether we should seek permission from the judge for ministers to have advance sight of the judgment.
Yeah.
If we scroll down and over the page to page 2, please. We can see at paragraph 10, it says, regardless of the legal findings, Post Office expect the judge to continue to be critical of some aspects of Post Office's handling of the case and its treatment of claimants. We expect these largely to relate to historic behaviour and do not believe that the Post Office currently has problems with its operational culture. Did you have at this stage any views as to the current operational culture of the Post Office?
Yes, my views of well, whether it's current, I don't know. Drawing from my experience with my constituent, I was inclined to think that the management of the Post Office was insensitive to and dismissive to the point of abject rudeness to some postmasters.
Paragraph 11, while Post Office Limited is 100% owned by Her Majesty's government, it operates as an independent commercial business. As such, the relationship with its sub-postmasters and the legal management of its IT systems are operational matters for the Post Office Limited. So again, reference to operational matters. The legal defence and the costs involved are being handled by them. If we scroll down and over to page 3, please. Paragraph 14 says your department's legal and UKGI legal advisors have consulted relevant government legal department litigation advisors and advised that such an application is highly unlikely to be successful. So it's unlikely to succeed if you did apply to see the judgment in advance. And then at paragraph 15, as well as being highly unlikely to receive permission, the application for permission and the judge's response will be made public. An application would run counter to the position the department has taken thus far regarding this litigation, including in parliamentary questions, namely that it is an operational matter for the Post Office. Reference here to a position that the department has taken. Can the distinction between operational matters and other matters, can that sometimes be used to advance a particular position?
Well, it was the long-standing position of the department over many years, over different administrations, that it was the case that the contract between the Post Office and sub-postmasters and IT systems were operational, and therefore litigation around it was also operational. My view was that that was entirely dependent on the judgment of the court, and were the court to find, as it did, that the Post Office had behaved as disreputably as it had, then that marked it very firmly as strategic. So, so he is reporting or repeating the inherited line. In my own mind, I was very clear that this judgment was going to determine whether this was operational or strategic.
And then at paragraph 16, therefore we advise that the Minister does not seek permission to have early sight of the judgment. UKGI will work with Bayes Communications and with Pol to ensure that appropriate responses are made as soon as the judgment is out. Could we please turn to UKGI 409137, please? And this is a further submission. A few days later, the 5th of March now. This is a submission from Alex Chisholm, the Permanent Secretary, to yourself.
Yep.
He says, you asked me yesterday to look into some issues relating to the Post Office and to advise you, both you and Kelly, on the way ahead. Do you recall the conversation that you had with Mr. Chisholm?
Not in detail, but I recall enough about it to be able to make some observations, if I
yes,
if I may.
please.
So the timing, as you say, I think it was shortly after that submission that we've just looked at. My view was that the result of this court case, which I regard as important, was about to come out. I had a notion that this would be significant, and I didn't entirely, trust is the wrong word, I wanted a different view to the UKGI view, which we saw in the last submission. So in the weekly meeting, I had a meeting one-to-one with the Permanent Secretary every week, normally every Monday morning, and I said, you give me, Alex, your own view of this, write to me separately, and it's why I think he describes it as a kind of personal minute or something like that. It's not a submission which tend to be kind of agreed across the department by sort of multiple people. This was direct from the Permanent Secretary to me and Kelly Tolhurst, who was then the Post Office Minister.
And it says the two most pressing issues relate to the court case and the appointment of an interim chief executive. And in relation to litigation, he says as follows. He says, I agree with the legal and policy advice that we should not seek permission to see the judgment in advance of it being made public and not comment when it is published. To obtain an advance copy, we would need to satisfy the judge that there was a clear public interest in such. This is difficult in any case, but especially in one such as this, where there are no immediate consequences, and we have presented the trial as being an operational matter for the Post Office. That comes back to the same point I was making before as to the use of the word operational to perhaps distance the department from it.
Yeah.
Is that something you would agree with, that it was to some extent used for purposes?
It's hard to know what was in the Permanent Secretary's mind when he wrote that. My own view was that the court case and the judgment would determine whether this was an arm's length matter or something that was directly for the department. It may be that he took that view, it may not be, so I think it would be unfair to me to read into his mind on that.
Thank you. Then says this is only the first of 4 trials scheduled to continue until at least March 2020, and the final outcome will not be clear until they have all completed. Ministers will want to keep an appropriate distance from the trial and not comment directly while it is sub judice, which is the point that you made. The Post Office may wish to appeal if the judgment goes against them. Personally, I would not be surprised if the proceedings uncovered some faults on both sides of the litigation. Hence, it would be especially advisable to stay above the fray for now, leaving you free to speak and act as necessary and in the public interest once the matter is decided. He then addresses the position of the interim CEO and is satisfied that Al Cameron is the right person for that particular job.
Yep.
Moving now to the judgment. So the judgment was the 15th of March.
So perhaps just to kind of comment on that. Certainly the paragraph 1 about the early side of the judgment and such like that was a kind of second opinion that I'd sought on the UKGI advice, just in summary.
And that was broadly consistent.
He was effectively supporting the advice of UKGI on that.
Where he says, I would not be surprised if the proceedings uncovered some faults on both sides.
Well, I had more in mind, I think it did echo that, but also that we shouldn't seek permit. The key issue to hand was whether the department, rather than UKGI, who were getting it anyway, should try to obtain the judgment in advance. And UKGI said, you shouldn't, because there's no precedent for this ever happening for a shareholder, and the Permanent Secretary agreed. So on that basis, I think we didn't apply.
At this point, was there a difference in view that you could sense between the Permanent Secretary and UKGI in relation to where the fault may lie?
I'm not aware of, I can't recall any difference at that stage, not to say that there wasn't any, but I don't recall it, although I think the fact that I went to the Permanent Secretary and asked him to give advice, as it were, on UKGI's advice, I'm sure in my mind was that the Permanent Secretary was not, as it were, wholly on the same page in general as UKGI. If I'd known him to have the identical view, there would have been no point in going to him in the first place, but I didn't, and it was direct and personal to him.
Thank you. That can come down. The judgment was the 15th of March. Paragraph 51 of your witness statement, you've described it as seminal.
Yes.
Can you briefly assist us with why you consider it to be seminal?
Well, it was seminal, as I set out in my witness statement, in a number of respects. I mean, first is that this was a long-awaited verdict. After a long period of litigation, perhaps too long, and the parties to it, the sub-postmasters and mistresses wanted to see it, but that's probably the most trivial sense in which it was seminal. It was seminal in another sense, in which it is the first time, in my recollection or in my view, that a court of the land had opined on this question of justice for sub-postmasters and mistresses since the individual courts that had handed down criminal convictions. There'd been, arbitrations that had gone nowhere. There'd been, I now discover but didn't know at the time, a review by the Post Office chairman, commissioned by a Silken assistant on that. There'd been all sorts of things done internally, but this was the first time since those convictions were made that a court had opined on it. And it was, so that was, as it were, it was seminal in anticipation. It was seminal in terms of its content, because the judge was very clear that the sub-postmasters and mistresses were right, and that the Post Office had behaved disreputably, as I think I describe it, and to the considerable detriment of the claimants.
Could we please turn to UKGI 409213? There was a meeting on the 16th of March. If we could scroll down on this page, please. At the bottom of the page, we can see, I think this is an email from is this your private office?
Yes, Clark MPST is my private office.
All thanks for joining the call this morning. A quick readout below with action. So that it seems as though there was a call with a number of participants. If we scroll down, we can see who attended.
Can I just describe the context of that, Mr.
Absolutely, please do.
So the judgment was handed down on the Friday afternoon, at a time when I was in my constituency with engagements, and that evening I had an important commitment, a revocable commitment in my constituency, but I wanted to have a meeting to discuss the judgment, so we did at the first opportunity, which, I mean, this readout is 9:45 in the morning, so I assume it would have been 8:30 or something like that on Saturday morning.
Thank you. If we scroll down, can you assist us with who these participants are?
Yes, SOS, obviously me as Secretary of State. Kelly Tolhurst was the Post Office Minister at the time. Will Holloway and Jacob Wilmer were my and the Department's Special Advisors. Gavin Lambert was by then the Director General, that's to say one below the Permanent Secretary with responsibility for this area of policy. Tom Cooper was the UK GI representative on the board of the Post Office. Tom Cartledge was one of my private secretaries, the duty private secretary. It wasn't, as I recall, his specialism, but it was Saturday morning. He obviously had drawn the short straw to be on duty that weekend. And Hibek Saeed, I assume, which says PS, so that must be Kelly Tolhurst's private secretary.
Thank you. And if we scroll down to the detail, it says as follows. It says, Kelly brought the Secretary of State up to date on the judgment against the Post Office, indicating that the judgment was close to the worst case scenario. There's some detail there from Tom Cooper. It then says, the Secretary of State asked about the prospect of an appeal by the Post Office. Tom Cooper discussed the legal advice received by the Post Office. This advice will require careful consideration. Tom indicated that there are both legal and tactical reasons for the Post Office to appeal, and that it is most likely that they will do so. Appealing may be unhelpful in reaching a settlement.
Maybe helpful.
I was going to say, just pausing there, can you assist us with the discussion regarding legal and tactical reasons?
So I was incensed by that remark. It seemed to me that this was a very important judgment that was strongly critical of the postmaster, of the post office, and supportive of the sub-postmasters. And it was instantly evident that that needed to be accepted and acted upon. And what really stung me was the use of the word tactical in this. There are tactical reasons to appeal, and it's most likely that they will do so. That suggested to me that this wasn't because there was something unclear in the judgment. It wasn't that there was some kind of area of law that was needed to be clarified or some material fact that was wrong, but that it was, well, at least I inferred, that this was, in effect, to disadvantage the sub-postmasters in their litigation, which should not have been in anyone's mind.
There aren't speech marks around the word tactical. Is that something that you actually remember from this meeting being mentioned?
Well, tactical, I assume, was mentioned because it's a very specific word, and it's, I mean, the fact that it says, I mean, the private secretary was a very experienced private secretary. He captures two aspects, both legal and tactical, so it was clearly pointing to something other than the legal. And I mean, I say in my witness statement that my reaction may have been unfair. It might have done an injustice, and perhaps it wasn't intended in the way that I interpreted it. But all I can tell you, and what I recall, is that I took that as meaning that there was an intention to play, it was a pretty appalling thought, a kind of a legal game with this rather than to respect the judgment.
It then says, the Secretary of State made clear his primary objective is to see justice done. I think in your witness statement you've said that that is a diplomatic way of putting it.
So for those that are not, have the good fortune not to be kind of connoisseurs of kind of ministerial minutes and readouts, there is a general understatement to what is kind of recorded in this. But there is a kind of code that I think people understand if they read it. And whenever it says something like, Secretary of State made clear. That means that I intervened with some force on the issue. It's not Secretary of State said, or Secretary of State observed, or Secretary of State suggested. SOS made clear is, if you take evidence from other civil servants, I'm sure will confirm, that means something. That means that this was pretty emphatic.
Is that one level below full and frank?
I think it's probably a level above. I think it probably implies that I was pretty direct about it.
And it then continues, where postmasters and...
Before you go on, can I
Yes.
have a quibble with this? I think I recall my demeanour on that call. I was quite angry about it. And in terms of making clear, I don't think I would have said, let me tell you, my primary objective is to see justice done. I think I would have said, did say, my only objective. And that's how it should be read.
It then continues, where postmasters and mistresses have been treated improperly, they should be treated justly. It will be necessary to consider the legal advice carefully to ensure no activity by your department will prejudice any appeal. The Secretary of State and Kelly discussed the possibility of making a statement. The Secretary of State resolved not to make a proactive statement. He asked that an urgent question rebuttal be prepared for Monday morning. He also asked that the department put out a statement making the point that we are aligned with the interests of the postmasters, but that we are still going through the legal process. Do you recall if that statement went out or not?
Yes, it was I think in the evidence that was disclosed, there was a written ministerial statement that I think was issued on the Monday morning.
So that's a written ministerial statement
Yes.
when it refers to a statement.
Correct.
Yes. We should also...
It's probably a press statement as well, actually. I think I suspect it was both.
We should also do a Dear Colleague letter promising to revert to the House when the legal matters are completed. It should be robust in tone and making clear that the litigation is ongoing and that Her Majesty's government will keep the House updated. The Secretary of State made clear that where the Post Office can fix problems internally before the conclusion of the legal process, it should do so. It then says he agreed with Tom Cooper's assertion that caution would be required to ensure that justice is done for legitimate claimants, but that restitution may not be appropriate in all circumstances. I think you've said in your witness statement that the reference to your agreement is again the civil service speak of.
So I think both of these are a little opaque. The first sentence of that paragraph, Secretary of State made clear that where POL can fix problems internally before the conclusion of the legal process. My recollection is I told them to get on with giving restitution to postmasters and postmistresses. There was enough in the common issues judgment for that to be initiated. They'd waited long enough, and they shouldn't, as it were, wait for the conclusion of the process. They should get on with it. To this last point, so Tom Cooper, and I think I infer from the last sentence that in the sentence before that they should give restitution to the postmasters and mistresses. I think I said comprehensive restitution. They should all be put in financially, at least, in the kind of position that they should have been in had this not taken place, to which Tom Cooper clearly made an observation that I think has been familiar from other evidence that the inquiry has taken, that, well, there may be some people that actually were convicted and were genuinely guilty of criminal deeds, and it would be an abuse of public money if they were compensated when they shouldn't be. To be frank, I didn't have much patience with that. I didn't think that was the import of the judgment. I don't recall Mr. Justice Fraser as having made a kind of great play of that. But it's hard to dissent from noting that, yes, of course, if someone clearly isn't entitled to it, they shouldn't get it. So, but there's not much emphasis I would have placed on that aspect.
I'm going to turn to two related documents. Could we please turn to UKGI 409296, please? This is internal UKGI correspondence. If we scroll down, we can see an email there from Richard Watson to Tom Cooper. And he says, Tom, I spoke again to Bayes Legal. While they agree it is a board decision, we think that if the Post Office decides to make the application, it should leave open the possibility that the Minister, after her discussion with Tim tomorrow, would want to say the shareholder disagrees. This is talking now about the recusal application. Legally, the shareholder cannot force the board not to make the application, and our advice to the Minister is not to get involved. But if she is adamant she does not want it made, that may be a matter for the board will want to consider. So this is the 19th of March, and it's discussion about whether or not the Minister should have a say in the decision to recuse.
That's right.
And if we scroll up, Mr. Cooper responds, really, question mark, and then Mr. Watson said, are you free to speak? And there is a further correspondence on the same point. If we turn the last document before the break to UKGI 409308. And perhaps if we could start with the bottom of page 3. We have, if we scroll up, we have Mr. Chisholm's view as expressed to Mr. Cooper regarding recusal. He says, I've now read all this legal advice. Personally, I find Justice Fraser in this case, as in the Madnox case, to be opinionated, exacting and rather inclined to personalise matters, but not, to my layman's mind, obviously wrong or biased. I also share the concern that a recusal attempt risks further antagonising him, if unsuccessful, and also positioning the Post Office in public as aggressive and in denial about its shortcomings, which impression would be consistent with the judge's findings to date. However, my personal view of the case, formed from a rapid perusal of the judgment and all the legal commentary you kindly provided, does not matter, as A, I'm not a lawyer, and anyway, B, the department is not controlling the case. That's properly a matter for the Post Office and their advisors. If we scroll down, I'll just read a few passages from the bottom of that email. It goes on to say, proceeding with the appeal and recusal attempt risks identifying the organisation's leadership today with the negative historic behaviours of which the Post Office stands accused, but it is not obviously mistaken or otherwise inappropriate. The board will want to reflect carefully on all these matters. For my part, I'm satisfied that the Post Office board is the right body to do this and that it has been properly advised. The department should maintain its clearly distinct and detached position so that it is free and credible for dealing with the consequences as they unfold. Ministers may want to show appropriate concern about the criticisms and may express a desire for the Post Office to act appropriately, but should not comment substantively in ongoing litigation in which the department has a clear interest but no direct involvement. If we scroll up, we can see that Mr. Watson, Richard Watson, if we scroll up again, sorry, he says, thanks, Alex. Thanks. Alex sums up my view perfectly. And if we scroll up, we have a further email that says, from Mr. Watson, that says, are we agreed that we should not try to engineer a position today whereby if the board decides to proceed with recusal, the Minister is given a chance to object, i.e. some sort of conditional board approval? As shareholder, I don't consider she has the legal power to prevent this, even if it was an appropriate thing for her to express a view on, which I think we agree it isn't, but instead is properly a matter for the board. It is, of course, proper for the Minister to understand the Post Office's decision and why their position might have changed since her call with the Chair on the weekend. I understand that might be the subject of a call with the Minister later today. And then Tom Cooper responds and he says, I have no intention of engineering such an outcome of the board meeting. And finally, if we scroll onto the first page, Mr. Evans, who was Deputy Director in Bay's Legal Advisors, he says, clearly the Minister should be given an opportunity to understand the Post Office's decision, but it is for the board to decide whether to apply for recusal or the variant described by Tom, guided by the officials and council, and there should not be a situation where the board takes a decision subject to endorsement or otherwise by the Minister. This should be a decision that is taken by the board on the merits of the litigation advice. Can you assist us with what your view was on the recusal application at that point in time?
Yes. I think it's a very important episode because it indicates that notwithstanding the strength and I would say unambiguous nature of the view that I and Kelly Tolhurst, I should say throughout this, the Post Office Minister's view, from whom you heard earlier this week, was identical to mine in this, in every conceivable respect, that the Post Office needed now to accept the judgment, give restitution to sub-postmasters and change their whole approach. And yet we discovered, I only discovered, I think it was on the Tuesday evening, so that call was on the Saturday morning. On the Tuesday evening, I got a message from Kelly Tolhurst asking to speak to me to say, you'll never guess what, they're now trying to recuse the judge. And I'm completely against it, as being incompatible with what we said. My view, again, was the same as that. They were going to do it, I think, the next morning. From memory, I think I was either out of Parliament or the department. I suspect it was an evening. I was probably speaking at some industry dinner somewhere. So I don't have access to these things, unfortunately, from my private office, but I think that I called the permanent secretary and asked him to get to the bottom of this and to advise Kelly and the board as to what we could do about it. And I think that is why his advice, I note that this email is 9:23 on the Tuesday evening, so it suggests that it's late at night. If I may make a couple of observations on the handling of this.
Let that come down, I think, while you do.
So the first is to say that I thought it was outrageous that UKGI contrived to keep the unambiguous view of ministers from the Post Office Board in making the consideration of this. It was my view, it was Kelly Tolhurst's view, even to the point, and you had it in the email that was up, about looking for an opportunity even for the minister, once they'd made the decision, and the strong legal advice from two sets of legal advisors was that it had to be made by the board, but even after they'd made it, should it be for recusal, we were minded to want to dissociate ourselves from it at the time. And that exchange about, I'm not going to, I can't remember what the words were, I'm not going to engineer a situation that was possible.
I have no intention of engineering such an outcome of the board meeting.
I thought that was wrong and appalling. In terms of the discussion at the board, I haven't seen, perhaps the inquiry has seen a kind of a verbatim account of what was discussed at the board. But the advice that Alex Chisholm, as permanent secretary, gave on my request, it went to Tom Cooper as to what he could do, what he could say. Even though it was, to my taste, a bit two on the one hand and on the other. I would have preferred a more robust piece of advice saying ministers are strongly opposed. Actually, what he does say, and you highlighted it when you called up the document, you're proceeding with the appeal and recusal attempt risks identifying the organisation's leadership today with the negative historic behaviours of which POL stands accused. And then he says, the board will want to reflect carefully on these matters. Now, in my view, that aspect of the Permanent Secretary's advice should have been put to the board so that they could consider that not only were ministers strongly opposed to this, even accepting that it was a decision for the board, but that the Permanent Secretary had some apposite things to say on what they should have in mind. I'm not certain, but it was the impression that I've formed is that there was a discussion in which, forgive me, it's not clear to me whether Tom Cooper said anything. I mean, he recused himself from the vote, but whether he did what was advised by the Permanent Secretary and set these concerns out. In my view, he should have done.
Thank you. So that might be an appropriate moment to take our mid-afternoon break.
Yes, certainly.
Could we come back at past, please?
Yeah, by all means.
Thank you
Fine.
very much. Thank you, sir. Can you see and hear me?
Yes, thank you.
Could we please turn to bays 4070, maybe 5070? Sticking with the recusal application, this is a submission of the 21st of March of 2019. The summary is that following independent legal advice, the Post Office's board has approved an application to recuse the judge. We expect this to be tabled today. If we scroll down, please. It says, over the weekend, you spoke to the Secretary of State and separately with the Post Office's chair, Tim Parker. So this isn't a ministerial submission to yourself, although you're a
To the
recipient.
Post Office Minister, I assume, is it?
Yes. And interim CEO designate, Al Cameron. Post Office informed you that they were taking independent legal advice on whether to seek an application for the judge to recuse himself from hearing the rest of the litigation. At that stage, Tim thought it unlikely that an application would be taken forward. Following these calls on Monday, the 18th of March, you sent a Dear Colleague letter to update MPs on events. Were you aware that it was originally Tim Parker's understanding that it was unlikely that there was going to be an application for recusal?
Only from this. I didn't know that there was any thought given whatsoever to a recusal application until Kelly Tolhurst called me on the Tuesday evening, I think it was. But I think this thing into which I was copied would be the first I knew.
If we
The confirmation of it, that wasn't the first I knew, but this was the first kind of official submission.
Thank you. If we scroll down, we can see it says on the 20th of March, the Post Office's board met to hear legal opinion on the recusal application and to take a decision on whether to proceed. Tom Cooper attended as the shareholders' representative to the board, but following advice from UK GI Legal, he took no part in the decision-making. Your department ultimately would have been funding this application. Is that fair?
No, I don't think that's strictly right. So the Post Office were funding the application. Now, of course, the government stood behind the Post Office, and there's a perfectly legitimate question that we might go on to is, again, how arm's length can that be? But certainly throughout it, the Post Office were, and I think there's some evidence that the Permanent Secretary reiterated that this had to come from the Post Office's own resources. So this wasn't, as it were, sort of coming to the department to fund that. Not that it makes it any more acceptable in my view.
Is it right for the UK GI member of the board not to vote, not to be part of that decision-making process in light of the reasons that you've already set out about the relationship between government and the Post Office?
Well, I've discovered quite a bit about this through this inquiry and its disclosures. At the time, it it was an evening call from the Post Office Minister and then a later night call to the Permanent Secretary. But what I understood, and I recollect, I'm sure accurately from my conversation with Kelly, was that she was being essentially told, given strong legal advice, which is to say that you can't intervene in this, you can't make this decision yourself, and I discovered ex post that it applied to Tom Cooper as well. Now, there's a very interesting thing here in the evidence that's been disclosed. Some of that advice, it seems to me from reading the to and fro, was advice from UKGI legal, that's to say from lawyers, but it was essentially presentational advice, not a requirement of the law, should we say. And since that was summarised, I think possibly, well, certainly in other correspondence, that legal advice was that the minister shouldn't intervene and Tom Cooper shouldn't intervene. I'm not sure that it's the right thing for presentational advice, which in any case, frankly, should be a matter for others and the ministers, for that to be passed off as legal advice. And if there were no legal bar on Mr. Cooper taking part in that decision, I was certainly of the view that he should have participated and should have spoken against it. As it happens, I could understand a genuine sort of legal objection to, as it were, the executive being involved in a criticism of the judiciary, but that would more apply, it seems to me, if the department or UKGI and Mr. Cooper were wanting the judge to be recused, whereas certainly the ministerial view and I think consistent with the reading between the lines of the Permanent Secretary's view is we didn't want that, we wanted the opposite.
Thank you. Could we please turn to UKGI 409464? So the submission I just took you to was the 21st of March. A few days later now, 25th of March, and you have received correspondence from another Member of Parliament, Anne-Marie Trevelyan, writing on behalf of a constituent, Peter Holloway. And she encloses, if we scroll over to page 3, please, an email from her constituent. And he says, I'm sure you're aware that judgment in the first part of the trial came down very strongly for the sub-postmasters, with strong criticism of the management of Post Office. We're currently in the second phase of the trial, looking at the Horizon system operated by the Post Office. We are confident of a similar outcome. The Post Office are fighting the case vigorously and are already considering appealing the first judgment. However, 2 of their senior managers have been found lying under oath in the court whilst giving evidence with severe adverse comments by the judge. I respectively request that you raise questions with the minister responsible for post offices as to whether they have seen the judgment of the court and what is the minister proposing to do about it. The government is the single shareholder of Post Office, and the government, in its own words, has an arm's length approach to managing the Post Office, and it is this very arm's length approach that has created this position whereby Post Office is in the middle of a train crash and refuses to see it. Meanwhile, people like me have been fighting for justice for over 10 years and have lost many hundreds of thousands of pounds at the hands of the Post Office. There are 550 of us in this joint action. Many have been forced into bankruptcy, some sent to prison, all severely disadvantaged, and the Post Office has been and is still spending millions of pounds of public money to defend its entrenched position and the reputations of an incompetent executive and a board that either doesn't care or doesn't understand what is going on. Over the last 10 years, there have been 3 inquiries, all of which Post Office refused to accept their findings, an attempt at mediation at which the Post Office refused to mediate. It's time for the Post Office to accept the true position and agree to settle with us who have been treated so badly. Is this correspondence that you recall receiving? Was it sent directly to you?
It isn't, and I don't expect I would have seen it for reasons that Vince Cable, I think, set out today. I think it would have been directed by the department straight to the Post Office Minister.
Were they sentiments that you were aware of more broadly?
Well, I'm not sure I was aware of them more broadly, but I couldn't have written it better myself. It basically reflects my views on the judgment.
But were they your views at the time?
Certainly, from that Saturday, from the Friday night when I first saw the judgment in my box, to the conversation on the Saturday morning when I, in effect, directed that it needed to be respected, and to the point here about the financial detriment that had been long-standing, my clear instruction was that that needed to end. There needed to be a restitution.
Could we turn, please, to Bayes 5071? This is a ministerial submission of the 12th of April. If we could scroll down, it updates you on developments since the submission of the recusal application, and it says in the first paragraph, the judge dismissed the application on the 9th of April and refused permission to appeal, but the Post Office will now seek the Court of Appeal's permission directly. In parallel, the Post Office is preparing an appeal of the Common Issues judgment. The recommendation is to note the contents of this advice and indicate if you wish the Post Office to give you an oral briefing to supplement this, as well as to outline its appeal strategy once the board has decided. If we scroll down, please, over the page to paragraph 8, we can see a section entitled Legal Team. And it says as follows: the Post Office has decided to boost the legal team and has provisionally appointed Herbert Smith Freehills to oversee the litigation with a direct mandate from the board rather than through the company legal counsel. Their mandate will be to revisit the approach to the litigation, both substance and tone, which in the short term means looking at the appeal relating to the Common Issues trial, the currently adjourned Horizon Issues trial, and the strategy for reaching resolution. What did you understand by the reference to substance and tone?
Well, I think the Common Issues judgment, I described it as seminal, and it was finding, it was in effect directing that the Post Office needed to accept the unfairness of its treatment of some postmasters and mistresses, and that it needed to, the tone thing is to conduct itself in a more respectful way.
Continues, the Post Office is open to making other changes depending on the advice received from the new firm. Given the unexpected outcome of the Common Issues trial, we have been pressing the Post Office to ensure that their litigation strategy is considered with a fresh set of eyes. So this is a good outcome, and we expect it to have significant bearing on the way the litigation is conducted. We then have a further ministerial submission in May. That's at Bayes 5073. 10th of May. By this stage, Herbert Smith Freehills has reviewed the legal strategy. If we scroll down, we can see paragraph 5. Following the appointment of Herbert Smith Freehills to oversee the litigation with a direct mandate from the board, they have reviewed Post Office's legal strategy. They presented their advice on a proposed approach to the Common Issues trial. This approach was endorsed by the board's group litigation subcommittee. In broad summary, they will be appealing, and then it sets out A, B, C, and D, the points that they will be appealing. And then it says below, in relation to the recusal application, the Post Office applied on the 11th of April directly to the Court of Appeal for permission to appeal the judge's decision and for the second Horizon Issues trial to be stayed in the meantime. It doesn't seem at this stage as though the litigation strategy has actually changed very much, does it?
No, to coin a phrase, nothing has changed.
Were you aware by this stage of any changes to the substance and tone as proposed in that earlier submission that we saw?
Well, so that first submission that you put up did indicate that they were taking the direction that had been given by me and Kelly Tolhurst immediately after the Common Issues judgment. I don't know whether you can put it back up, the end of that first of the two that you just shown, that they were appointing this new team to review the strategy, to report direct to the board and to change the substance and the tone. So that was encouraging. What was very disappointing in this, I should just say for completeness, I've seen this in what was disclosed to me, but I don't think this submission was sent to me. It was to the Permanent Secretary and to the Post Office Minister. But through conversations, I would be aware. I would have become aware of it. I was, I suppose, looking forward, with some anticipation to seeing the outcome of this review by a fresh pair of eyes, and then to find that it, in effect, is taking the same approach was bitterly disappointing.
Could we please turn to Bayes 5075? And this is the final significant ministerial submission that I'm going to take you to today, and it's from the 11th of June.
Mm-hmm.
So this is a ministerial submission to you to approve. And it says as follows: at the industry meeting on the 4th of June, you, Secretary of State, asked for advice on how the ongoing Post Office Limited litigation should be brought to a swift and satisfactory conclusion, ensuring sub-postmasters who had been treated unfairly were appropriately compensated. So starting at the beginning there was what is the industry meeting of the 4th of June? Do you recall?
So I describe in my witness statement that my pattern, as well as having every Director General give to me their thoughts every week, direct to me, I had a series of what I regard as important internal meetings in which we would discuss with the relevant minister present, in this case the Post Office Minister, usually the Permanent Secretary and senior officials, things that were on my mind or a decision that one of the junior ministers was going to take that they wanted or I felt that they should have some collective discussion. So this was a weekly meeting of these things and senior officials were present. I would observe that it says at the industry meeting on the 4th of June, and we will certainly have had a discussion resulting in this commission. My recollection is that there were discussions before that as well, from around the time of the two submissions that you put up, in other words, the weeks ahead. They quite probably were, or quite possibly were, at one of the other industry meetings. Unfortunately, the department doesn't have minutes of those meetings. And certainly I would have, in my weekly discussions with the Permanent Secretary and with the Post Office Minister, have been essentially kind of preparing the ground for a major intervention in the Post Office to cause them to do what manifestly I'd hoped that they would do from that Saturday after the Common Issues judgment, in other words, to settle, to set up a restitution scheme, to change their whole legal approach. I hoped that they would do that, as it were, voluntarily. By this stage, I'd essentially given up on them and concluded that they needed to be forced to do it.
There's reference there to appropriate compensation. At that point in time, what did you have in mind?
Oh, the full detriment. I mean, the detriment can never be overcome. I mean, the loss of reputation, the disruption of people's lives can never be properly compensated. But certainly financial compensation and something that was an attempt to deal with that. There are various references you'll probably see later in this submission to kind of worrying about the costs of this. If there's one thing I would communicate very clearly is that there was no way that I was going to see the compensation, the entitlement to the sub-postmasters, see them sort of bilked to kind of protect the for the convenience of the post office or even the Treasury and the government. They needed to get what were their deserts.
There are a number of recommendations. The recommendation is that you note the advice and our recommendation that you choose from the following options, which are not mutually exclusive. 1, challenge the Post Office Chair and Board to review their litigation strategy. 2, commission the Post Office to carry out a project on how to structure and operate a settlement. 3, Bayes ministers to state publicly that they want to see justice resulting from litigation for claimants with valid claims. 4, challenge Post Office to announce that it is taking on board some of the legitimate criticisms in the judgments and taking action. 5, put UKGI lead legal counsel or another legal advisor on the Post Office litigation subcommittee as a director or observer. 6, invite Nigel Boardman, chair of the Bayes Audit and Risk Committee, to carry out some independent due diligence on their litigation strategy. 7, put in place clear information sharing arrangements via the proposed framework agreement for the Post Office. And then it says more radical steps are presented in option 8 to 10. We recommend these are not pursued at this stage. I think did you ask for what was called nuclear options, or what you call nuclear options?
My purpose in requesting and requiring this package of advice, which I think took some time to put together, so that the interval between the industry meeting and this submission, I think, is slightly misleading. I think this was in train before that, was essentially that I wanted the direction that I'd in effect given on that Saturday morning to be put into effect, up to and including dismissing the board, taking over the litigation by the department.
Thank you. If we scroll down over the page onto paragraph 6, it says there, the current status of the litigation is that a hearing on the 23rd of May, the judge denied the Post Office permission to appeal his judgment in the first common issues trial and awarded the claimants their costs of the common issues trial rather than reserving this judgment until later in the litigation. Setting out his reasons in a written judgment of the 4th of June, the judge criticised the Post Office's conduct again, namely the Post Office's veiled or implied threat that mirrors the approach adopted by the Post Office on the recusal application, namely that in adopting a course of action in the face of opposition by the Post Office, runs the risk that the Post Office will say that the overall outcome of the litigation has already been decided. The judge also expressed concerns about the escalating costs of the litigation. Yeah. In your witness statement at paragraph 96, you have said that the Post Office had not accepted the significance of the previous judgment.
Well, it's to my remark that nothing had changed. Clearly, that even at this stage, on the 4th of June, so I'd commissioned this advice, probably better, more accurately described as a kind of set of actions to force them into line. I'd commissioned it before this judgment, suspecting that they were not doing what I had directed them to do. And lo and behold, the judgment of Mr. Justice Fraser, who seems to have been very alert to the Post Office's conduct, says that even now they're engaged in the kind of behaviour that he deprecated in the first common issues judgment. Almost unbelievable.
If we scroll down, please, to paragraph 14, there's a section there regarding the role of government as sole shareholder. And it says that at the bottom, this does not include explicit powers to direct the board to take a specific course of action, although over the page it says, though ultimately ministers have the right to appoint or remove any member of the board. And I think we'll get to it, but that was potentially one of the nuclear options that were proposed.
Indeed. I mean, there is throughout this a continuing anxiety on the part of the department that it's an arm's length limited company in which the power of ministers is confined to approving the strategy and to appointing or firing individuals, not to direct them. And there was, I think it's here, there's a kind of in fact, there it is in paragraph 16. There's a warning that, care needs to be taken that ministers do not risk being regarded as shadow directors. A shadow director is someone in accordance with whose directions or instructions the board are accustomed to act. Now, it was very much my intention that the board should act in accordance with my instructions. They were alive to that. They were drawing my attention to it. So we were skating on somewhat sort of thin legal ice, as it was described to me, which is one of the reasons in my recommendations that I don't think we should have needed to tiptoe around it in quite that way. For God forbid that there should ever be a future case, but in future, that sort of advice should not need to be given.
Was there a point at which you actually considered, in effect, becoming a shadow director?
Well, it was in my mind from the Saturday morning that I had a clear view as to what the Post Office board should do, and I was going to do everything I could to make sure that they implemented it within the law, hence this discussion, but I was prepared to push the envelope, shall we say.
If we scroll down at 19, the recommendation was you choose from options 1 to 7, either individually or collectively. If we briefly turn to Bayes 5076, we can see the annex to the submission, which sets out the options and the advantages and the risks. If we scroll down, we can see at page 4 the additional options that were potentially available. Go public with a stronger Secretary of State statement, change the chair, change the board, scrolling down, change the management team. Further down, Bayes to take shared responsibility for the litigation. So those were options 8 to 11.
Correct.
Very briefly, why did you discount those options?
Well, so as you said, Mr. Blake, these were options that I'd asked to be included, and I didn't so much discount them as start with the. So I think what I said is I want all of the above in terms of the top 7, and to keep on the table these to see whether they could be. See whether they would act in the appropriate way. I think the top one of these additional ones, to make a strong statement, actually I think that's not very different from what I did direct, which is to say that we were on the side of the sub-postmasters and the litigation had to change. But in terms, so the others essentially amount to one way or another dismissing the board, either explicitly in terms or through perhaps the option 11 taking responsibility for it. They, I think, might be likely, probably would have been likely to quit on the basis that, it's a lack of faith in our competence. So essentially they boil down to a question of, at that point, should I fire the board? Now, that's something that I certainly wouldn't shy about doing. I have used my powers in other organisations to remove people that I thought were not competent or performing or had certain problems associated with them. But it's a step that one has to take advisedly, it seems to me, as a kind of Secretary of State. This was an organisation without a chief executive. At this point in time. The interviews, I think, were being conducted that week for the new chief executive. Nick Reed was someone that was appointed a few weeks after that. So it's an organisation, running the Post Office it's a complex organisation. It's absolutely essential for national infrastructure of paying benefits and applying for passports and all the rest of things. So I would have had in my mind that in order to instantly, summarily, as it were, dismiss the board. You'd have to have an alternative arrangement in place. To have an organisation as important without any leadership would be quite a big step. In addition to that, I would certainly have had to consult the Prime Minister and others were I to do that. So my view, it was certainly not taken off the table, quite the opposite. I
Shall
was
we
dismayed.
Shall we turn to your confirmation of the options that you
Yes.
did choose?
Yeah.
That can be found at UKGI 30010205. So this is the 18th of June 2019. I think you were only in post for about a month after
Yeah.
this. And it says, Secretary of State has reviewed this advice and has expressed a preference for the first 7 options to pursue, content for you to proceed on this basis, and we can discuss further at industry meeting when next scheduled. Can we turn back to the submission? So that is Bayes 60 or 5075. Thank you. And if we could scroll down and look at the recommendations. How many of those recommendations are you aware were actually fulfilled?
I can't say. There were various actions that were implementing the recommendations, much of which was about the minister appearing at a POL board meeting, which I think was in a few weeks' time.
And in respect of public statements, for example, were they carried out during your period in office?
I can't remember. I think we did in terms of, well, some of these were already done. For example, 3, I think in the communication after the common issues judgment, we said that we were aligned with the postmasters and mistresses, and we wanted to see restitution. So actually, I think that was already in train.
Could we please turn to poll 00285354? The suggestion might be made that you should have done more of those more quickly. Mm-hmm. What do you say about that?
Well, when one takes a decision like that, there are different ways of implementing it. One was, and I don't know whether we got the date, there was an important appearance that Kelly Tolhurst was going to make at the Post Office Board to tell them what to do. One of the other aspects was that the new chief executive was about to be appointed, and no doubt he would be, he or she, it turned out to be he, would be the conduit of that. But in general terms, I think it would be fair to reflect that given how dilatory the Post Office were, that actually to have been more directive a few weeks earlier might have saved a few weeks in this. I think that would be a reasonable reflection to make.
I just get one thing straight in my head, though. Unless I got this fact wrong, there would seem to me to be quite some difficulty in actually doing very much at all in June 2019. Because was it not in June 2019 that the Horizon Issues trial started? So that it's very difficult to imagine doing anything while you're actually conducting that litigation.
Well, thank you, Swin. I was aware that the Horizon Issues trial was going on, but for example, in the drawing up of a scheme of compensation...
Sorry, perhaps I put it too broadly, so I'll stop you. In terms of generally the litigation strategy,
Yes.
As opposed to the broader issues
Yes.
of compensating the Post Office, I've just been musing to myself about how anything meaningful could be done while the Post Office lawyers are on their feet, busily fighting the postmaster's lawyers before Mr. Justice Fraser again.
Well, so when I would say that my hope and intention was that the approach that was taken to that Horizon trial would be different from the approach that had been taken throughout the common issues period, that they would be looking to
I'm
acknowledge the
going well beyond my terms of reference, but it seems to me that once the Horizon Issues trial started, of course, there could be a difference in tone and the way you approached people. I don't mean you personally, I mean the post office and the government. But effectively, the choice was either to fight the case properly and legitimately or to give up. That's what it boiled down to. What I mean by give up, start making real overtures about settlement. I mean, those were the only two practical options at those days, weren't they?
Well, I would agree with you that in terms of settlement, that was going back to the readout of that Saturday morning conversation. I can't remember the exact words, but it was something to the effect of that we shouldn't wait for the end of the legal processes to settle, in effect. So that was part of it. Part of these points that we've just been talking about were to begin setting up the structure of a compensation scheme. But I'm not a lawyer, so let alone a legal expert. So to what extent my hopes that the conduct of the post office's participation in that trial could have been changed, I had hoped and intended that that was possible, that it should happen.
All right, thank you. Okay.
Could we please turn to poll 00285354? This is the final document I'll take you to before we move on to recommendations. This is an email of the 30th of September 2019, so it's after your time in office. It's an email from Alistair Cameron to Nick Reed, and it relates to potential changes, structural changes. It says, in the conversation, there are multiple stakeholders with varying needs, which I've tried to set down in the attached, which should not be forwarded, please. I don't think and I think that's some sort of responsibility assignment matrix is the answer, because they won't abide by it. It seems to be relating to UKGI and how to manage that relationship. And the document that's attached to that can be found at poll 00285355. And there are various comments from Mr. Cameron. I'd just like to get your view on these, because I think you did meet Mr. Cameron on a number of occasions. So Bayes, Secretary of State, that may be a reference at that stage to Andrea Leadsom rather than yourself, or to the Post. It's not entirely clear, but it says, usually the Secretary of State has no strong feelings except not being embarrassed by us. The group litigation order is important because we're being sued by postmasters. Politicians have mixed feelings about us, but love constituency postmasters and will always side with them versus us if they can. When we make it difficult, it's stressful. Were you aware of those views as expressed there?
Well, when I first saw this document, I assumed wrongly that it was referring to me, and I don't believe that anyone could think I didn't have strong feelings on the matter, but I think it's my successor. I thought this whole document was pretty cynical. It's looking, as we go on, to looking at ways in which these stakeholders can be, as it were, sort of managed, it seems to me.
There's a section there on Alex Chisholm, and it says, Alex doesn't want us to do anything that might damage his career prospects. Alex meets us very rarely to date. His views have been developed starting with the last funding round, when he and Greg Clark concluded that UKGI had gone native, and they were anxious about government investing via us commercially, not their skill set, and how they stop us throwing good money after bad. And it's that in particular that I want to ask you about, where it says that you concluded that UKGI had gone native. Is that a fair reflection of your view at the time, and if so, why?
I don't think I would have put it in necessarily those terms, but certainly during the funding round, as is referred to, it was my responsibility as Secretary of State, along with the Permanent Secretary, to ensure that public funds were not wasted. And I felt that there were, I think the Permanent Secretary felt that there were proposals that were being made to invest in quite large sums of money in different ventures that seemed to be dubious in terms of their likely value for money. And I think there's a structural problem here in that UKGI, we may come on to talk about this a bit more. UKGI is a sort of deal making. It's a kind of, it's a private equity type organization who I think the people in it structurally are kind of keen to do deals and to do the things that you do in corporate finance. And so in our scrutiny of UKGI, I think we were pretty wary about their views, and they were more aligned with encouraging the post office to do things that we didn't necessarily think were judicious.
It says that Mr. Chisholm has been infuriated by the GLO, which he thinks should have been settled ages ago, and said so last year. Do you recall Mr. Chisholm having said that the GLO should have been settled considerably earlier?
I don't, and so I don't recall him having said that. For the reasons that I gave, I think, earlier in our discussion this afternoon, I thought it was important that litigation concluded, that it were not. I can see from a sort of department, from the Permanent Secretary's point of view, to have it sort of dealt with might have had its attractions, but I think a lot of what was in the very comprehensive judgment would not have been in the public domain. And if you take the view that I do and did, that the criminal convictions, the unsafety of the lack of safety of the criminal convictions was as it were, the keystone of the edifice. I think pursuing that litigation, I think, was important for that. My concern, having seen partly what happened, going right back to the beginning of my evidence of the supposed settlement mediation through Second Sight, that was not satisfactory, and so I think it needed that resolution. But that's a long digression. I did not know that Alex Chisholm took that view.
If we scroll down finally on this document, there's a reference to UKGI, and it says UKGI has the role of overseeing government's commercial interests. They're generally ineffective and pleasant. Very briefly, what was your view of UKGI?
Well, I've got great respect for the people who, often after distinguished commercial careers, give up their time to be on the board of UKGI and to serve in their public interest. And I don't want to say anything critical about them. But I think there is, reflected on this over the weeks and months ahead, I think there's something of a kind of emperor's new clothes quality to UKGI as an organisation. That, with hindsight, I think I and perhaps others should have pointed out. I mean, let me give you some examples, some of them perhaps trivial. It talks about its assets the whole time. We're managing the asset. We're dealing with these are our assets. It's a peculiar way of talking. These are, the post office, the nuclear decommissioning authority, the Ordnance Survey. They're not assets. It sort of denotes. No one in government would talk about the assets. They are organisations. They're public bodies. Why not call them public bodies? I think the fact that it's a limited company is a bit peculiar. Why do you have a limited company with all of the downsides in terms of being able to direct and that we've discussed, when it doesn't charge for its advice? I don't see why it should be a limited company. And to have a limited company giving advice on another limited company I think is a bit peculiar. And this whole thing of having memorandums of understanding with departments, the business department didn't have a memorandum of understanding with the Treasury or with the communities department. Wanted to work together. So I think there was a kind of cod corporate finance arrangement to this that actually I don't think was appropriate and necessary.
If I could bring onto screen the Memorandum of Understanding that was in place during your period in office. That's UKGI 17461. It explains under background, UKGI is a limited company wholly owned by HM Treasury. And then it says at 2.2, to facilitate UKGI in managing its work and resources and to enable the constructive engagement of UKGI with the department it advises, memorandums of understanding are expected to be put in place for the benefit of UKGI and the department it works with. UKGI service. UKGI will provide independent advice to BIS and its ministers to deliver BIS objectives. Any direct engagement with assets or projects will formally be as agent of BIS. UKGI will provide its advice in a manner consistent with the civil service's core values of integrity, honesty, objectivity, and impartiality. It then has a section on accountabilities and responsibilities, and it says the accountability to Parliament for the activities UKGI is involved in will be, and then it says ministerial level, BIS ministers. And if we scroll over to the fourth page, it sets out there what it defines as the activities as at the 1st of April 2016. And one of the assets, as you say, defined under assets, is the post office. If we scroll back to the first page, so it says on the first page, paragraph 4, the accountability to Parliament for the activities, i.e. the post office, at ministerial level, BIS ministers. Irrespective of the legal interpretation of this Memorandum of Understanding, do you understand there to be a clear link of accountability of UKGI?
No, and I think it's obscured somewhat by its organisation as a limited company. I mean, I think I say in my witness statement that it describes itself as being owned by the Treasury, and accountability is to Treasury ministers. I think it obscures. It seems to me that sort of simplicity is the best way to proceed. I never had any difficulty in understanding the role of civil servants. And again, they're not part of the civil service. I don't know why not. There are norms in the civil service as to how to proceed. I don't think it needs that. I understand that one reason, I suspect, I don't know, but I suspect one reason for creating this sort of limited company arm's length body is to be able to pay people more than the civil service pay scales allow. But that's a good example, it seems to me, of setting up something to get round a problem rather than to address it. If you need senior corporate finance people in government to advise ministers and permanent secretaries, then rather than sort of set up a limited company to employ them, why not have an exception and be direct about it, it seems to me.
How would you improve, very briefly, the line of accountability?
Well, I would certainly have UKGI reporting. Well, I would prefer the advice to be within the department. It has to be from officials within the department. There's another example of this, and in preparing for this hearing, a number of the other public bodies, the Nuclear Decommissioning Authority, an asset in terms of UKGI, had obviously not a similar, but a kind of a related problem in which it got into a contractual tangle. UKGI were not very effective in spotting it and bringing it to the attention of the department and ministers. As Secretary of State, I commissioned a review by a man called Steve Holliday into that, and it reported, I think, a couple of years ago. And interestingly, one of its recommendations is that the complexity of this sort of governance is excessive, and it should be there should be based civil servants directly on the board, and that's, it seems to me, a preferable way of operating.
One of the things that you've referred to in your proposed recommendations is something called a public interest company. Very briefly, how do you envisage that would work?
Well, it's a thought rather than a blueprint, but the thought is this, that some of what we've been talking about has been, advice as to about whether you're going to be a shadow director. Is this the responsibility of the board? Do you have standing as a minister to direct it or not? And a lot of this comes from using the kind of vehicle of an ordinary Companies Act company to contain businesses, organisations like the Post Office. And it seems evident, I think, from our conversation this afternoon, that there is a combination of public interest and commercial interest. In other spheres, in charities, for example, we have a corporate form. The charity law states, I'm a trustee of a charity, how that should be, because it's a particular way of organising things. There are things like community interest companies that have their separate governance. So just for simplicity, to recognise that there are some organisations in which there is pretty much sort of jointly and severally a public interest as well as a commercial interest, and to make it very clear that ministers and officials are absolutely at liberty to have information to direct, as it were, proceedings there, it seems to me would make life a whole lot easier.
Some people have blamed individual actions as well as structures. How would you guard against that?
Well, there'll always be individuals who don't discharge their duties to as well as they should. When we're talking about UKGI, I've been very struck, and I'm the latest in a series of witnesses who've been members of the government, that many of my predecessors have been critical about individuals who've been employed by UKGI. I think Joe Swinson was, Baroness Neville Rolfe, Margot James, Gally Tolhurst, and others. I think that actually points to a kind of structural problem, that they are in a dilemma, or at least are, perhaps because of the requirement to be a member of a unitary board, are drawn into a certain way of proceeding at the expense of another. And this is not a kind of trivial observation. I mean, one of the purposes of UKGI is to be good at governance, to improve the government's capacity at governance. But I have to say, on the evidence of this, and I think on the NDA, the evidence is that they have not been very good at that in important instances. For example, the failure of UKGI to bring to the attention of the Post Office Board, let alone ministers, the Parker Review, the Swift Review, which was highly consequential. That seems to me to be a failure of corporate governance in which UKGI was part. I might also add, which was news to me until the evidence of this inquiry was disclosed and reported. I had no information given to me that the board had a lack of confidence in Paula Venables, for example. UKGI did. You've had conversations, I know, about ministers from successive administrations being being aware of what happened in the previous one, I think that would have been very material to know that the board had expressed in the past, at least a lack of confidence there. So even as corporate governance specialists, I don't think the record of UK GI is all that robust, should we say.
Thank you. Very finally, you've clearly watched a lot of, or heard a lot of the evidence from this inquiry. Are there any recommendations that didn't make its way into your statement that you can think of now, briefly?
I tried to reflect on all of these. I do say something about the pattern of evidence. I mean, it seems to me kind of standing back, and I think it, in public policy and public life generally, one of the things that I've been interested in recent years, chairing the Science and Technology Committee of the House of Commons, is the development of artificial intelligence. Artificial intelligence, I'll explain the relevance in a second, spots patterns that actually, as it were, the naked eye may not spot. I think if the pattern of prosecutions, convictions had been spotted better and earlier, then certainly a lot of the time to resolve these matters might have been shortened, and in many cases, by getting to a recognition of injustice earlier, some people might have been saved the appalling effects that they had. And so some of the recommendations I make in my witness statement is to give responsibility, whether it's to the CPS or other bodies, to actively monitor unusual patterns so that they can be brought forward earlier. But here am I, as it were, sort of freelancing into an area that is judicial, in which I'm not really qualified. But so I mentioned that because you asked me whether there was anything else I included in my witness statement, and that was a reflection that I made.
Thank you very much. So I don't think there are any questions from core participants, unless you, sir, have any questions.
No, I asked the few that I needed to as we went along. So thank you very much, Mr. Clark, for your witness statement, for your oral evidence, and also for your reflections. A number of your fellow current or past politicians have addressed their minds to reflections. So I think I'm right in saying that currently, at least, you are the last politician who's going to give evidence in this phase. And so I would thank all of you, and you use the vehicle, for providing me with plenty to think about in terms of how I make recommendations for the future.
Well, thank you, Sir Wynne. And if I'm put in the position of my colleagues to thank you and the inquiry for the meticulous approach that you're taking to it. Thank you.
Right, Mr. Blake, tomorrow we resume at 9:45.
That's correct, sir, yes.
We have a part-heard witness, do we not? And then Mr. Edwards, is it? Yes, it is, Mr.
That's correct, yes.
Fine. All right then, 9:45 tomorrow.
Thank you very much.